I'm waiting for the man. Sits down, we can start. No, don't hesitate. Yep, it did go on. Thank you very much. Bill, it's not yet winter as long as Bill Bond is wearing short pants. That's the answer, right? So thank you all for being here, and this is a real treat. I'm so looking forward to hearing from Marianne. So I just briefly, my name's Tom McHenry, and I'm your Dean and President. And if anybody's visiting from afar, this is our Doug Costle Lecture. Doug, who I have a picture of here, died last January, and I got to go to his memorial service in Washington, which was in the same chapel where he got married. Unfortunately, soon after leaving the deanship here at Vermont Law School, Doug suffered a debilitating stroke and was incapacitated for much of the rest of his life. He lived for another 20 years. But his daughter told some wonderful, endearing stories about him. And he was able to say a few words, only a few, and he was very musical, and he loved listening to music, and so his children would play music for him, and they would listen to music together. But his daughter revealed that two of the favorite words that he used were ice cream and vodka. So I thought, if it's going to happen to you, those are things you should know about. Doug was a lawyer. He worked as a trial attorney in the Justice Department Civil Rights Division. He crafted the study that led to the Environmental Protection Agency, and then was appointed by President Jimmy Carter as the administrator of the EPA, a position he served in until 1981. He then served as the Dean of Vermont Law School from 1987 to 1991, and it was during that time that we built the beautiful Cornell Library right over here. He was also a founder of the Institute for Sustainable Communities, now up in Montpelier, a nonprofit which builds environmental, economic, and social infrastructure in existing and emerging democracies in the world, along with Madeline Kunin. And there's a lovely quote from Doug that I'll just read before I turn the podium over to our ELC director, Jenny Rushlow, and it is as follows, I quote, "A taxed and tired electorate may well wonder if there will ever be an end to this struggle, whether we can ever get ahead of our pollution problems. My conviction is that we will, that it will be a quiet victory, but it may be the most important victory any nation has ever won." And I think if Doug were here today, the only substitute he would make in that quote would be to say the most important victory our world has ever won. So it's delightful to be able to honor Marianne with the Doug Costle Lecture, and we're all looking forward to it, and I will turn it over to Jenny Rushlow. Thank you.
Good evening. I have the pleasure of introducing our speaker tonight, Marianne Engelman-Lado. For those of you who are already working with Marianne, this isn't news, but she is an exceptional environmental justice lawyer and advocate. This year, she's visiting VLS as our Costle visiting professor and chair, and she's directing our new environmental justice clinic, which is really a privilege that VLS gets to have her here to do this work. As well as being a visitor at VLS, she's also on the faculty of Yale's School of Public Health, as well as their School of Forestry and Environmental Studies. Prior to that, she had a career at Earth Justice, where she was a senior staff attorney, where she focused on civil rights enforcement and the effects of environmental contamination on vulnerable and overburdened populations. She served for 10 years as general counsel for New York Lawyers for the Public Interest, where she focused on environmental justice and racial and ethnic disparities in access to health care. And she began her career as a staff attorney at the NAACP Legal Defense and Educational Fund, where she represented clients attempting to break barriers to health care and quality education. She holds a bachelor's from Cornell, a JD from Berkeley, and a master's from Princeton. And her lecture today is titled, "No More Excuses, Building a New Vision of Civil Rights in the Environmental Justice Context." Now, I know that when I was in law school, I wanted to do exactly what Marianne does, and hearing her would have been the highlight of my law school experience. So I really hope that we'll deliver on that tonight. And with that, I will welcome Professor Engelman-Lado.
Well, that's a little scary. That's a little high bar. So I can't promise this is going to be the lecture of your life, but I'll try. So you've already heard that I have a civil rights background that I bring to this work. Let me actually get the clicker. Okay. And a little bit about my background. So let me jump right in. That's a little visual image of what you just heard. So as you may know, in 2016, the Flint Water Advisory Task Force, with 5 members appointed by the governor of Michigan, with backgrounds in utilities, policy, public health, medicine, and environmental protection, found that the events that led to the water quality debacle, which is what they called it, in Flint involved callous and dismissive responses to citizens' expressed concerns. A year later, the Michigan Civil Rights Commission report, looking at the same series of events, was even more blunt. As a result of their year-long investigation, the commission found that race and racism played a significant role in causing the Flint water crisis. Not at all surprising was any of this for people living in Flint, or more generally in Michigan. Flint residents and other Michigan community organizations filed multiple complaints with EPA over years, alleging that the Michigan Department of Natural Resources, now called MDEQ, or the Michigan Department of Environmental Quality, failed to comply with civil rights. But EPA's Office of Civil Rights had repeatedly failed to identify clear red flags signaling a pattern of discrimination at MDEQ over time. Multiple complaints against MDEQ for discrimination on the basis of race and ethnicity were dismissed as untimely or just ignored. EPA neglected to consider whether allegations created reason to believe that MDEQ was in non-compliance. 2 complaints focused particularly on MDEQ's decisions to permit facilities in Flint itself, raising concerns about the racially disproportionate impact of polluting facilities on Flint residents. The first of these, actually the second chronologically, but the first I'll talk about is Select Steel, a somewhat infamous case out of Flint filed in 1998 by the St. Francis Prayer Center, which, by the way, is a client in our clinic. The St. Francis Prayer Center filed the challenge to MDEQ's decision to permit the Select Steel facility. Perhaps no single case is more emblematic than Select Steel of EPA's failure. Michigan had issued a Clean Air Act permit for a proposed recycling plant in an already deeply polluted area that was largely African American. The complaint raised concerns about the process for approval, and also, ultimately, the impact or the potential impact of this facility, which, even when permitted, even if complying with the permit, would emit lead, and there's no safe level of lead, manganese, mercury, dioxin, and VOCs, volatile organic compounds, to name a few. In order to make a finding of discrimination under Title VI of the Civil Rights Act of 1964, under which the complaint was filed, the agency needed to find that there was an impact, and that impact fell disproportionately on the basis of race. So that includes the adverse impact and disproportionality on the basis of race or national origin. Traditionally, in civil rights law, showing disproportionality to a significant level is the challenge. But at EPA, finding that there was an adverse impact was the challenge. Evaluating the complaint, EPA used environmental standards, the National Ambient Air Quality Standards, as a method of assessing whether there was an impact. Even though no amount of lead is safe, EPA said, well, if the facility is going to comply with our environmental standards, there's no cognizable impact. And therefore, no affected population would suffer an adverse impact that was cognizable under the civil rights law. In Select Steel, therefore, EPA dismissed allegations on the ground that the Flint-based facility would have no adverse impact, despite predicted emissions of VOCs, lead, mercury, and other air toxins. Less well known is another St. Francis Prayer Center complaint filed by Father Phil Schmitter and others at St. Francis Prayer Center in 1992 to challenge MDEQ's, the Michigan Department of Natural Resources, decision to permit the Genesee Power Station, a complaint that was accepted for investigation in 1995 and then languished for decades. The complaint alleged that MDEQ discriminated against African Americans on the basis of race in the way it ran the permitting process, and also, again, that the facility would have a disparate impact on the basis of race. In a December 15, 1992 letter to EPA, Father Phil Schmitter and others at St. Francis Prayer Center said, "We write to you because this is a diabolical example of blatant environmental racism and classism. Another time, people of color and low income are targeted. We are sure you are well aware of the higher percentage of poor and people of color who bear the onus of this pollution while receiving much less adequate health care." They noted that the facility would be directly across the street from two low-income housing complexes and trailer parks within a third of a mile. Among other things, residents raised concerns that African Americans were treated in a discriminatory manner in the permitting process. While the Air Pollution Control Commission that ran the meetings, accommodated white elected officials who wanted to offer comments during the process, by adjusting the schedule of the hearings, it refused similar requests by black state elected officials, two state representatives, Floyd Clack and Janice O'Neill, who also wanted to testify. The commission also combined the hearing on this facility with hearings on other facilities and held the hearing 60 or so miles away in Lansing, finally getting to the issue of this facility at the end of a 10-hour hearing, after which people would have to drive home and put their kids to bed, although it was well after bedtime. It wasn't enough that the hearing was so far from home, but residents were reportedly treated rudely and had to stay so late in order to testify. When finally, after all the complaints were in about this hearing, the commission held another hearing in Flint in an African American neighborhood near the site of the facility. It posted 2 uniformed guards at the hearing, deviating from any process they had previously used. Notably, the hearing in Lansing had been held without armed guards at the door. It should also be noted that by the late 1990s, 60,000 people lived in the neighborhood, the North Flint neighborhood, near the site, while the community hosted 227 environmentally noxious facilities, posing potential or proven health risks. These included sites for hazardous waste generation, solid waste disposal, hazardous treatment, storage and disposal facilities, and other sources known to be toxic. So what happened to the complaint? Filed in 1992, it was accepted for investigation in 1995, and I should say, under regulations, EPA is required to acknowledge a complaint within 5 days, make what's called a jurisdictional decision about whether to accept the complaint, and investigate it within 20 days, and then they have 180 days to decide, to make preliminary findings of discrimination and any recommendations as appropriate. So they get the complaint in 1992. It takes them 3 years rather than 20 days to make the jurisdictional decision. In 1998, they sent a 4-person team to go investigate, and this team writes up findings, I'm told, of discrimination, finding both that MDEQ treated communities differently on the basis of race, that is, that had discriminatory intent, and also that the facility would have a discriminatory impact on African Americans. But this draft was never released. In fact, it just gathered dust. When I was at Earth Justice years later, we filed suit against EPA on behalf of the St. Francis Prayer Center and 4 other communities that had complaints at EPA that were gathering dust for EPA's failure to complete their investigation, which by law is only supposed to take 180 days. And in 2017, after the height of the publicity around the Flint water crisis, EPA finally released its second ever finding of discrimination in this case, finding that MDEQ discriminated, intentionally discriminated in the process of reviewing the permit for the Genesee Power Station. EPA said that it had significant concerns that MDEQ's public participation program now was discriminatory, and that it wasn't sure that MDEQ could ensure that discriminatory treatment wouldn't occur today. They also said they didn't think MDEQ took seriously its responsibility to implement a properly functioning non-discrimination program, and they made some recommendations. In the remainder of this talk, I hope to address 3 questions. 1, why did this happen? Touching on my research, why is it that EPA can't mount an effective civil rights enforcement program? 2nd, who cares? When I was doing graduate work, whenever you presented something, you had to answer the who cares question. And I want to answer that today. That is, why is EPA's civil rights enforcement program important? And then 3rd, what can we do about it? If you agree, as I do, as I believe, that it is important, I want to outline some of what we can do, which is part of the work that's undertaken by our EJ clinic. Before I get into any of this, I just want to say something I should have said at the beginning, which is how happy I am to be here, and how happy I am not only to be in this room tonight, but with all of you for the semester. And a big shout out to my students in the EJ clinic. It has been just such a warm and welcoming environment, and I really appreciate every time people have reached out to me, and seeing this room filled tonight really warms my heart as well. Well, I think you clapped because it was the most upbeat thing I've said so far. I went to a session yesterday that said you're supposed to start everything with a joke to grab attention, and I thought about it, and I'm just not a funny person. So I'm sorry about that. This is a somber topic, and I'll try better next time. Anyway, why did it take between 1992 and 2017, 25 long years when the community started living in the shadow of Select Steel and Genesee Power and the 200 plus other facilities, why did it take all that time to make a finding of discrimination? The short answer is EPA is really bad at this. EPA has a poor record of civil rights enforcement and has done a terrible job. There's a long history to this, and I have up here just one example of a report, this one from the U.S. Commission on Civil Rights from 2016, saying that EPA is chronically unresponsive in their civil rights program. Of course, this doesn't explain why, but I'll just tell you that this is not just my point of view about this. When Lisa Jackson came into office in the Obama administration, she actually asked Deloitte to do an audit. Said, what's going on here? Why are we so bad? And Deloitte confirmed, you're just really bad. You're chronically understaffed, you don't have training, there isn't leadership, this isn't professional. They didn't say this in the report, but the kind of word on the street at EPA is this is sort of the dumping ground for people who aren't all that effective. Now, there are plenty of people who are effective, including a VLS grad who's absolutely wonderful. But they're just fighting uphill. And I wanted to figure out why that was. I would also commend investigative reports by the Center for Public Integrity, which further shined a light on OCR's chronically unresponsive Title VI program. They actually did a FOIA request and got data on all of the complaints. There are something like 300 complaints that over time have been filed with the Office of Civil Rights at EPA. And they looked at all the public documents and they started crunching the numbers. What did EPA do with these complaints? And what they found, which we knew, is that EPA has never made a formal finding of discrimination, never made a referral to the Department of Justice, never even began to withhold federal funds, which is the ultimate remedy for a finding of discrimination. So my research interrogates why EPA has failed to develop a forceful civil rights compliance and enforcement program and what can be done. EPA's failures since its founding are well documented, and the relevance of and need for civil rights enforcement in this space are also well known. So why hasn't EPA acted? Well, before I answer that question, I'm holding you in suspense, I know. I just want to take a step back and say, what is this Title VI of the Civil Rights Act of 1964? And say a few words about it for those who may be less familiar. This is the act. And most importantly, the first paragraph, no person in the United States shall, on the ground of race, color, or national origin, be excluded from participation in, be denied the benefits of, or be subject to discrimination under any program or activity receiving federal financial assistance. It's a broad remedial statute. It prohibits participation, exclusion from participation in, denial of benefits, or discrimination in any program or activity receiving $1 of federal money. And notice that the word, where we got this thing, the word discrimination does not say intentional discrimination. It just says subjected to discrimination. This second section here gives the agencies that give out federal money authority to pass regulations and to enforce the law. So MDEQ, for example, at Michigan, back to Michigan, is subject to Title VI because it receives federal financial assistance from US EPA. So US EPA, like all federal agencies, essentially has regulations which define prohibited activities. And they define discrimination not only as intentional discrimination, but also as actions that have an unjustified, disproportionate impact. So what do we got? We got potential violations for intentional discrimination, actions, policies, or practices by a recipient of federal funds that have an unjustified, disproportionate impact, potential claims of exclusion from participation in processes. I don't have up here, but intimidation is also prohibited, intimidation or retaliation. Failure to evaluate disparate impact can be a form of noncompliance, and failure to provide language assistance is both a form of discrimination and also a form of exclusion. One major limitation is that unless you can show intentional discrimination, under a 2001 5-4 decision from the Supreme Court in Alexander versus Sandoval, the Supreme Court ruled you can't go to court. Technically, the rationale is that there's no private right of action for disparate impact claims, and I'm happy to talk more about the case during Q&A if you're interested. But the key for our purposes is that after 2001, after Sandoval, communities and advocates seeking to make a claim that there was an action that discriminated because it had an unjustified, disproportionate impact on the basis of race was left only to file their claim with the administrative agency that had given the federal funds. You can't go to court independently to make the claim. So we rely on EPA to address issues of discrimination by recipients of federal funds from EPA. So that might be state agencies. It might also be a private facility that gets federal money from EPA. So what's the problem here? Well, as I said, EPA is pretty darn terrible at enforcing the law. If we look at, do I got this? Oh, there we go. Look at the US Department of Education that, by contrast, has developed a pretty effective program. In 1 2-year period, they handled 4,600 Title VI complaints. And they did 32 compliance reviews. That is, they don't just wait passively for a complaint to come in, but if they have reason to believe there's discrimination in a program or activity receiving federal funds, they pick up the phone and they say, hey, Burlington School District, you got a problem. You got a testing program or a suspension program or a tracking program. that seems to have a disparate impact. Let's talk, let's figure it out. Let's change that program so it doesn't have that disparate impact, or at least let's review whether your disparate impact is justified. We don't want a racially stratified society, so if you're getting outcomes that are unequal on the basis of race, let's at least review whether they're justified. Sometimes they are, but let's review that. By contrast, EPA in this 17-year period, the reason I chose those weird numbers is those are the years of the FOIA requests by the Center for Public Integrity. 17-year period, they handled 300 complaints. They accepted 64 for investigation. They made 1 preliminary finding. They made 2 after Michigan, and did 1 compliance review. Actually, that one was sort of a mistake. It was a complaint that they came in that they treated as a compliance review. They have never taken the initiative on their own to affirmatively investigate. In fact, during the height of the Michigan water crisis, when I was at Earth Justice, we filed a letter on behalf of a whole bunch of community groups, not saying this is a complaint. We wanted to get them to do a compliance review. So we held back. We said, you have reason to believe that there's a problem here, that there's discrimination. Why don't you do a compliance review? And they rejected that and decided, no, we're not going to do a compliance review. Okay, so you got the idea. So let's talk about why. Well, I want to turn to this why question, which has been the focus of my research and also my most recent article. A number of factors have been posited to explain EPA's poor record of civil rights enforcement. EPA has argued for a brand of exceptionalism, saying that indeed its partnership with states and tribal governments and regional authorities that receive federal funds create a tension with enforcement activities. Such relationships, while now baked into the ethos of the agency, actually are not entirely unique. You think of HHS having a federalist relationship to states to carry out the Medicaid program, for example. Instead, I would argue EPA's history as a latecomer to civil rights enforcement, its brand of federalism, the composition of its staff, and the structural characteristics of the program sort of created a cultural brew. So the culture of EPA has then led and has reinforced a lack of political will. Note that the Civil Rights Law was passed in 1964, and it was used by Health, Education, and Welfare, the forerunner of the Education Department and HHS, to desegregate hospitals and schools across the country. There's a great book on HHS's use of Title VI called Healthcare Divided, which I commend. EPA, by contrast, was established in 1970, after the height of the civil rights movement, and indeed during some of the worst moments of the backlash. EPA's first administrator, William Ruckelshaus, brought to EPA deep environmental experience, but at best, ambivalence about spending any political chits on civil rights. At a 1971 hearing before the U.S. Commission on Civil Rights, when asked what EPA would do to enforce the law, the civil rights law, he argued that EPA was in what he called a peculiar position as a regulatory agency attempting to cajole communities into compliance with water standards. If EPA threatened to withhold federal funds for sewage treatment, say, to an all-white community, say, in the Cleveland area, for example, that community might bow out of contributing money for the project. He said, our ability to achieve the purposes of the Civil Rights Act flies in the face of our mandate by Congress to ensure that water quality standards are complied with. Of course, parallel trade-offs had been made at HEW. When HEW threatened to withhold funds from hospitals, it risked the possibilities that they wouldn't participate in the Medicare program. And of course, school districts did close down for a while rather than desegregate. From the beginning, this cultural brew contained at least skepticism that addressing racial inequality and discrimination in the environmental sector was a core responsibility of the agency. There's also a healthy dose of defeatism, a lack of confidence that the agency can ever enforce civil rights law. Now, imbibed by those in the agency, the mixture has given rise to a lack of political will. So as part of my research, I examined these various theories to explain the variance between the poor record at EPA and the more effective program at education. I looked at grant size. That seemed reasonable, a plausible explanation, but it turned out not to be a strong explanatory factor. I interviewed leaders at the offices of civil rights across agencies and asked for their opinions. What characterizes an effective versus an ineffective civil rights program? And what factors contribute to those outcomes? I asked about structure. For example, some agencies have regional offices. Some combine internal, like EEO, equal employment work, and external civil rights compliance. A key takeaway from these interviews was, however, that leadership matters. While this seems to be, what this seems to be leading to is that the best explanation for EPA's poor record is not its federalist exceptionalism. It's true that EPA does rely on federal-state partnerships, though as I said, so do some other agencies. EPA personnel also skew whiter. That's true as well. But these are contributing factors to a culture at EPA, one that's much influenced by the date of creation and its struggle to obtain credibility, as well as the resulting priorities in leadership. The good news is this can change. So I don't need to tell this group of people about the history of and the record of inequality in the distribution of environmental benefits and burdens. Racial inequality is baked into the distribution of environmental benefits and burdens in the United States, given our history of segregation and stratification. Indeed, as Richard Rothstein's The Color of Law and Dorsita Taylor's work shows us, the location of polluting sources is inextricably bound to the legacy of segregation and discrimination. Rothstein writes, for example, that zoning has two faces. One face attempted to keep African Americans out of white neighborhoods by making it difficult for low-income families, larger numbers of whom were African American, to live in expensive white neighborhoods. The other attempted to protect white neighborhoods from deterioration by ensuring that few industrial or environmentally unsafe businesses could locate in those white neighborhoods. The racial aspect of decisions to permit toxic waste facilities in African American areas was a desire to avoid the deterioration of white neighborhoods when African American sites were available as alternatives. And we see this over and over and over again in communities where decisions were made not to put facilities in white communities, but to put them in the African American or Latinx communities. A large body of research since this seminal United Church of Christ study in 1987 shows the significant relationship across all regions of the country, across many forms of pollution, between polluting sources, exposure, and race. In fact, across many of these studies, race is the most salient explanatory factor, more than socioeconomic status. In 2019, we should agree, and I'm sure we do, that this is unacceptable. All children should have the opportunity to grow up with clean air and clean water. And we should not be exposing children of color to more pollutants than any other children. Another way I hope to get at this question of why does this matter or who cares is to just tell you a little bit about one of the cases we work on. This is a second struggle for justice, this one in North Carolina. And I want to talk about the ways in which we were able to leverage a civil rights complaint even under these adverse circumstances that I was talking about, having to rely on EPA and our work in tandem with community activism. And this is a case that is now part of our clinic. So I need to take a step back and just say, as we talk about in the clinic, the goals of legal action are not solely to get a court to rule in your favor. Of course, all cases must be meritorious. Right? We don't bring frivolous cases. Having said that, there are a number of ways in which cases can support community campaigns and community activism. They might create political space. For example, using NEPA, right, to give space for public participation. Articulating a narrative. Quite often, communities in low-income communities of color feel that their experience of racism just isn't out. If we bring an environmental case, we can talk about racism, but it doesn't fit into the legal framework. So by talking about civil rights, it helps to create space for the narrative that they believe helps to explain their disempowerment and the relationship between the history of racism in the country. Of course, legal action can also help build a record. You can also use FOIA and public disclosure laws to build a record, and it can, in general, support community-based movements. So, when I got to Earth Justice, now like 10 years ago, I called up, I should say that when I was at the Legal Defense Fund many, many years ago, the Legal Defense Fund was led by a wonderful guy named Julius Chambers. There's a great biography of him that's out right now, aptly named Julius Chambers, maybe Julius Levon Chambers. But he was an amazing guy, and he had argued Swan. For those of you who have done constitutional law, he argued Griggs. He's just an amazing guy, and he was from North Carolina. And people in North Carolina in the late 1980s, early 1990s, when I was there, started calling Julius and saying, we got a problem here, and it's a civil rights problem. We've always had hogs in North Carolina. We had something like 25,000 farms with one or more hogs, and they would take those hogs to market, and they would sell them. But now, the hog industry is being transformed. And we have these hog facilities with 5,000 hogs, 2,500 hogs, 7,500 hogs, and they are collecting all their waste. The hogs are not outside, they're all inside. The waste goes down through slats, the hogs are mistreated. You then get all this waste, and hogs make 3 times the amount of waste as people. And you gather all this waste, and then the waste is all put in an open-air cesspool, what's called a lagoon, and then it's the liquid, the solids drop to the bottom. These are all unlined, or at least they don't have synthetic liner. They have what's called farmer clay, which is supposed to pack in. And then the liquid rises to the surface, and they spray it over spray fields. And I'll show you some pictures. I hope nobody's eaten too much today. They spray it over spray fields, and what people were saying is, I used to go out on my porch, but now I can't, because this spray is carried by the wind and onto my porch. I used to hang out my laundry, but now I can't. And this is a civil rights issue. This industry is moving into eastern North Carolina, which is disproportionately African American and actually now Latino and Native American. And it is disproportionately affecting our way of life. And they wouldn't do this if we weren't low income and people of color. They wouldn't be allowed to do this. So we decided to try to do something. So when I was at the NAACP Legal Defense Fund, but I will tell you in all honesty, we couldn't quite figure out what to do. We did some research, we thought about tort cases, and I carried with me after I left the Legal Defense Fund this sense that this was unfinished business. This was a civil rights issue. People were absolutely right that they were being disproportionately affected, and we needed to do something. So when I had the opportunity to go to Earth Justice, and I had this health docket, this environmental health docket, or what they now call Healthy Communities docket, where we were working on civil rights issues and waste issues and pesticides, I said, can I work on the confined animal feeding operation issue, and particularly the environmental justice impacts of confined animal feeding operations? And it was at the beginning of the Obama administration, and Tom Perez had come into the Department of Justice, and he had said Title VI is the sleeping giant. We have to awake the sleeping giant. We have to enforce civil rights law. So I thought, great, let's try to enforce civil rights law. So I went to North Carolina, and I called up our friends at the North Carolina Environmental Justice Network, and they had been advocating for years. They had brought waste to the Capitol and said, look what we deal with. And actually they tell this story far better than I do, because I already told you I don't have a good sense of humor. But they did a protest at the steps of the Capitol, and they brought a little tub, and they brought some waste to the Capitol from eastern North Carolina, and they poured the waste in the tub. And when a guard came out, I don't know if he was armed or not, and said, you gotta get that waste out of here. If one drop falls, I will arrest you, or I will fine you for bringing toxic waste to our community. And Naima Muhammad, the head of or executive director of the North Carolina EJ Network, she is a good storyteller. And she relates how she said, funny, it's not toxic waste when it's out near our homes, but now suddenly by moving it here, it's toxic, it's hazardous. So they had done this. They had done everything they could. They worked with public health officials, a guy named Steve Wing at UNC Chapel Hill. He did studies after study about the health impacts, and he did it with the community, very community-based research. He did study after study of the health impacts and the other impacts of living in proximity to these confined animal feeding operations. He also did studies of who lives in proximity and the environmental justice impacts and the fact that disproportionately it was people of color who were being affected by these facilities. So we were able to pick up on those issues. First of all, I should say, we warned the community, EPA is really bad at civil rights enforcement. So don't give up on all your other strategies. This is in tandem with other strategies. But if you want, we can try to bring a civil rights claim. And we did, and they wanted it. So we raised, too quick. We raised a disparate impact claim, which you may or may not get. And we had to show that there was adverse impact. It affected people disproportionately on the basis of race, and to be ready to rebut the argument that there was a substantial legitimate justification, and the rebuttal is that there are alternatives, less discriminatory alternatives, or ways of mitigating the impact. Okay, so let me just quickly show you some of the impacts. So this is actually a dairy farm, but it gives you a sense. It's just a good picture. You see barns. You don't see any animals outside. This is in Missouri, not in Vermont, I should say. You see the lagoons, open-air cesspools. There's an open-air cesspool. Oops, we'll get to that. Let me go back. There are lots of ways in which this facility has an impact on the community. So there is smell coming out of the indoor facilities when you have the concentration of all those animals. The cesspools smell very strong. The spray fields, which I think there's one over there, when you spray, there's a smell. The impact on water, both from the cesspools and from the spray fields, can be tremendous. So thanks to the waterkeeper for this picture, this is after Hurricane Matthew. We can now predict a greater level of flooding and overtopping of lagoons. Manure lagoons, in this case, was completely submerged and mixed with floodwaters. The water body was immediately adjacent to the Neuse River, and during Hurricane Matthew, at least a dozen hog lagoons were inundated by floodwaters, leaking untreated hog waste. I don't need to remind this audience that this is only going to get worse, that these lagoons are supposed to, under their permit, be able to handle a 25-year, 24-hour storm event. 100-year storm events are coming through with some regularity, and they're just not built for that. There's also the problem that facilities often spray before a storm comes, oversaturating fields, leading to further runoff. So in this picture, you're seeing, if I can get this, oops. This is, okay. So this is a spray field. That's the sprayer. This is erosion on the spray field. You can see the waste coming off. This is Stocking Head Creek. And the erosion, you can see the waste just going right down to Stocking Head Creek. So I'm going to move through these slides quickly, both because some of them are disgusting, and also because I just want you to get a sense of what some of the harms we talked about were. Oversaturated spray fields, improper disposal of dead animals. I should have said that eastern North Carolina is the most concentrated area of the country for swine facilities. Also overlaid is poultry facilities. North Carolina is number 2 in swine, number 2 or 3 in the country in terms of states for turkey and for chicken. But it's not like Iowa. Iowa has a lot of topsoil, right? And Iowa, the facilities are across the whole state. In eastern North Carolina, they're all the pork facilities, all the swine facilities are in the eastern part of the state. So they're very concentrated. 9 out of 10 of the counties with the most pigs per person, in Duplin County, it's something like 40 pigs per person, are in eastern North Carolina. And it is a low-lying coastal area, sandy soil. It's not a lot of topsoil. So if you see something like this with the disposal of dead animals, red flags should go off, right? Or down, or whatever red flags do. So And why do you have, so you can always have dead animals. It doesn't have to be anything extraordinary. But I will say I'm working on the issue of community impacts of industrial animal agriculture. But some of our friends and partners are working on a whole range of other impacts, including the challenges resulting from the lack of biodiversity of these animals and what happens when you put so many animals with a lack of biodiversity inside in crowded conditions. Broken sprayers, that's an example of a broken sprayer. Air pollution, there are these enormous ventilator fans. If you didn't have these enormous ventilator fans, the animals, whether it's poultry or swine, would asphyxiate from hydrogen sulfide, depending on the animal, hydrogen sulfide or phosphorus or other things. And the fans blow out smell, obviously, but that smell is an indicator of pollution. Here's another picture of a sprayer. You can see the manure going off into the air. These are dead boxes. I should say that in the complaint we talked about, here, let me go back so you don't have to look at that. In the complaint we talked about water pollution, groundwater pollution, surface water pollution, air pollution, risks of adverse health outcomes, the rise of MRSA, antibiotic resistance, property value, interference with enjoyment of property. It wasn't only one set of adverse outcomes. And you can see how living near a facility that has a dead box where they put these dead animals and then a truck comes around and picks up the dead animals and drives through the streets, sometimes leaking bodily fluids on the streets, why that could be an interference with enjoyment of property. Proximity to sacred spaces, you can see the CAFO in the back there, and this is a family cemetery. And I won't spend a lot of time on health effects and the particular chemicals, but there is a large body of literature on that issue. And this is perhaps one of the most important slides. So right here is the home of one of our declarants. And this is a 3-mile circle. And this doesn't even show poultry facilities. In North Carolina, this is an issue I hope our clinic will work on, poultry facilities are deemed permitted. That means they don't actually have to apply for a permit, and DEQ says they don't know where they are, okay? They're deemed permitted. So long as you follow the rules, you don't have to go get a permit. When I was in the Yale clinic, we worked with Waterkeeper to ask the authorities that be to start regulating dry litter facilities. But in any case, this map doesn't show dry litter facilities. So each of these facilities here is a pork facility, is a swine facility. Usually, again, like 2,500 or 5,000 pigs, each with outdoor lagoons, 1 or 2 lagoons, with the equivalent of waste, an outdoor cesspool, of something like 7,500 or 10,000 people. Now imagine living within 3 miles of about 10 or 12 facilities, each of which has a open-air cesspool of the equivalent of waste of a town of 7,500 to 10,000 or more people. That's what the person living here deals with. Imagine the flies, the vermin, the vultures. The concentration in eastern North Carolina is extraordinary. And then just quickly, Steve Wing and Jill Johnston at UNC Chapel Hill did this analysis of racial disproportionality. This is what's called the Black Belt. You can see that all these facilities are located in a very small area. This is disproportionately African American. The red here, which sort of you can't even see under all these swine facilities, is more than 40% people of color. And these dots each represent one swine facility. If we were accounting for the size of the facility, it would be even more disproportionate. So it was very clear that there was impact and disproportionality. So we presented this complaint. We went to EPA. We said, here's the complaint. Please investigate. They accepted the complaint for investigation, and then we waited. And we sent briefs. We said, there's a cumulative impact with poultry. And we waited. And we guessed at what they were doing. And we sent additional information, pictures and declarations, and we waited. So finally, we decided they're not going to come and do a site visit. We'll go to them. So people packed into 2 vans, and they went to Washington, D.C., and I should say we have co-counsel at Earth Justice and the Lawyers Committee now in North Carolina. And here in the picture, you see Naima Muhammad. She is the executive director of North Carolina EJ Network, and Larry Baldwin from Waterkeeper. And there's a third group called REACH, which is a community-based group in Duplin County. And they presented their case, this is during the Obama administration, said, come, we brought a petition as well, come to North Carolina, smell the smell, see what's going on. And in fact, EPA did a site visit. To make a long story a little bit shorter, on their way out of town, the Obama administration sent a letter of concern. They couldn't see their way to making a finding of discrimination, but they did send this letter of concern, which was very powerful. They said that in the totality of the information they had been given, the types of adverse impacts described in the complaint are being felt by large segments of communities of color and are potential evidence of systemic concerns. There's a lot more in their letter, and they also made recommendations to look at mitigation, to assess what regulations were applicable to facilities operating under the swine general permit, and determine what would mitigate these adverse impacts, to evaluate the feasibility of other options to reduce the adverse impacts, including such simple things like not spraying on evenings and weekends, not using dead boxes, for example. So they left town, and in North Carolina, Governor McCrory was replaced by Governor Cooper. And with this letter of concern, we went to the new state administration, and we said, and they came to us and said, let's see if we can solve this problem. And we went into EPA's Alternative Dispute Resolution Program. And we actually were able to come to settlement. And our settlement agreement in May 2018 included the following: greater openness in the permitting process. The permitting process had this thing called a stakeholder process, which essentially from the community point of view seemed like industry sitting down with Department of Environmental Quality and saying, don't change the permit at all. Or if you tweak it in our direction. And while 1 or 2 people from the community were part of that, it was not an open process. So we said to DEQ, this should be an open process. You can't have a closed process and then say you're doing notice and comment, but if you make any changes during notice and comment, it's going to be too significant and it's too late, and we won't be on time with our permit, which is what they were doing. So they had a more open stakeholder process. We also talked to them about incorporating some of these recommendations that EPA made and having stronger permit terms. And while they couldn't promise us what would come out of a stakeholder process, they did agree that there could be, going into the stakeholder process, a draft that incorporated stronger permit terms. Some of those permit terms did come out of the stakeholder process. It wasn't what we wanted, it didn't solve the problem, but we got some incremental change. A Title VI civil rights program, including a new language access policy, a new public participation policy, and the development of an environmental justice tool to be able to look at what are the communities that are most impacted. And I'm seeing Emily here, I don't see John, but there's John. So Emily and John worked in the clinic this fall. They hit the ground running, and we had comments due on the public participation and the language access policy September 18th. So they hit the ground running and worked on comments on those policies that DEQ is now taking into account. The settlement agreement included air monitoring, water monitoring. So we have continued challenges in seeing these changes come to fruition, and of course they're only incremental. But I do want to say that even in this adverse circumstance, the Title VI program can make a difference. All of this work is in tandem with communities. And one of the great things about working in North Carolina is that we are working with the North Carolina EJ Network and other groups in North Carolina. They wanted to do this work because it highlights the issue of race discrimination, which had been very hard to get attention to. It also provides leverage that they couldn't get in any other way. And it provides some options like going into mediation. There's a lot to be said, but I want to say move to what can be done, and first a little bit about what we're doing in our clinic, and then what kind of structural change we need, and then I want to leave time for Q&A. So over the last 10 years, I've been working with a broad array of community-based individuals, groups, activists, environmental groups, civil rights groups in an alliance that is pushing for civil rights reform in the environmental context. And the clinic is working with this alliance as well. And the alliance uses many different strategies to push for short and long-term reform. And I'm not oblivious to the fact that we're in a really tough moment right now. So I'm trying to emphasize there are things we can do now, and then there are ways that we can look toward the future and prepare for a brighter tomorrow when we might have a more propitious moment for civil rights reform. So we can demand action on individual cases, and you saw that in the North Carolina case, that we went to DC. We said, you gotta take a look at this. We demand action. We're not just filing this for fun. There really should be some change here. We can pressure EPA and do advocacy, and during the Obama administration, we did comments on rulemaking. In our clinic, we're also beginning to look at what kind of guidance could EPA adopt if there were a new administration? How do we get a start on things given that we have some time to prepare? We litigate. So we and Earth Justice are working on behalf of 5 communities across the country, including the St. Francis Prayer Center, that filed litigation against EPA for their gross unreasonable delay in responding to civil rights complaints, and we won. I mean, it's sort of a no-brainer, right? EPA was, instead of 180 days, it was 25 years. So that's good facts, terrible facts, but that's good facts. So Judge Armstrong in the Northern District of California ruled in our favor. EPA couldn't take no for an answer, so they keep filing motions, motion to amend, and their motion to amend the judgment is before Judge Armstrong. And again, we can talk more about that, but we can do litigation. Communications. Communication is really an important part of our strategy. People had all but given up on civil rights in the environmental context. I bet there are people in this room who say, Title VI, that never works, right? And so we need to say, we are not giving up. This is an important strategy. And so changing the mentality that somehow civil rights doesn't apply. We have a carve-out for environmental decision-making where there's no accountability. You just get federal money and you can do whatever you want, whether it exacerbates racial inequality or not. We got to change the thinking around that. Legislation. We've been working with Senator Booker's office, Congressman Ruiz's office, EJ groups around the country to plan for the future, again, a more propitious moment. And Senator Booker and Congressman Ruiz introduced the Civil Rights Act of first 2017, now 2019. Congressman Grijalva and McEachin also have a bill that's bubbling up that we're working with EJ groups on. They're really taking the lead, and we're figuring out how we can provide technical assistance and be helpful. But there's legislation sort of in the works to build some momentum and to make change, including being able to go back to court to enforce the Civil Rights Act. Demanding the use of affirmative authority. This is part of agency advocacy. You can't just be passive and wait for a complaint to come in. What needs to be done to use affirmative authority? And then, of course, we use other strategies. If we're working with a community and civil rights does not avail, or we can't wait around for a civil rights strategy, we use environmental laws, we use state laws, and we can also develop intentional discrimination case. Throughout all of this, what the communities have told us is it's critical to be able to talk about race discrimination. And we do all of this in a way very intentionally that is consistent with the principles of environmental justice. So we take seriously these rights to self-determination, and Principle 7, these are the principles of environmental justice that were drafted in the early 1990s at the first People of Color Environmental Summit. Environmental justice demands the right to participate as equal partners in every level of decision-making. That doesn't just apply to government agencies, it applies to us. So as we think about how we run our clinic, how we do our work, we take seriously these principles of environmental justice. I could not imagine when I got to Earth Justice that the New York Times and The Nation and these other papers would be calling for EPA to enforce the Civil Rights Act, but indeed that happened while I was at Earth Justice as a result of the work of the Alliance. And I would just close by saying, not only in this clinic, but the clinic ties to this larger movement for reform, we can accomplish a lot. So during the end of the Obama administration, it may have been baby steps, but we saw some meaningful change, not only on the local level, or the state level. The changes in North Carolina are small but real and important, but also nationwide. So I want to acknowledge that during the Obama administration, the EPA actually, for the first time, developed a case resolution manual. Now that may seem small, but they never had a manual governing their procedures before. In fact, I'll tell you a little anecdote. We would meet quarterly with the administrator, and every time we met, they'd want to have something to show us. So one time we came, and they showed us compliance form 4700-4. It used to have an asterisk. This is the compliance form to say I'm getting federal money and I'm assuring that I comply with Title VI. So until, I think, 2013, there was an asterisk next to it, which said, saying you're complying with Title VI is optional. And so this big deliverable that the administration wanted to share with us was they got through OMB taking off the asterisk. So we take those baby steps forward where we get them. There were also some changes that the Obama administration made as they walked out the door. They moved what they called the External Civil Rights Compliance Office away from the internal EEO office, which is called the Office of Civil Rights. I don't know whether that was a good thing or a bad thing. My research suggests structure doesn't matter all that much. But at least it was a change, right? When something's not working, you gotta make a change. And they also moved the office, this External Civil Rights Compliance Office, out of the Office of the Secretary. Again, good thing, bad thing, I'm not sure. We argued a little bit about where it should go, but at least it was a change. At least we're getting some change. Long term, we need a much more dramatic change. And as we look to the future, we have to prepare for that change. So as I mentioned, there are a number of bills that have been introduced to restore the ability of people to go to court to enforce the law, rather than relying on federal agencies. Whether it's the Booker-Ruiz bill, Bobby Scott has a bill in the context of education, a private right of action to go to court is necessary. You can't rely on the agency. Even in the area of education, that's inadequate. For further study in my article, I try to provoke people a little bit to think a little out of the box and say, maybe we should not have civil rights enforcement dispersed among the agencies. Some will do it well, some will do it poorly. EPA has never done it well. This is not a partisan issue. It's across every administration, with all due respect to the name of this lecture. But across all administrations, it's never been done well. So why don't we think differently? Perhaps the Department of Justice should have centralized authority, and they can delegate to the Department of Education if they're doing a good job. Or perhaps we should have a new agency like the EEOC for handling civil rights compliance in the context of Title VI. Well, there are many steps we can take, short-term and long-term, and in the clinic we're trying to prepare for them. What we do know is that it's time to stop making excuses and to start enforcing the law. So with that, I'd like to thank you and invite your questions. Oh, there's a microphone up here for anyone who wants to ask a question, or if you're going to make a comment, keep it really short.
Hello. I'll kick things off while people get their thoughts together. So I'd like to hear your thoughts on the adequacy of the remedy available for a Title VI claim. So, the thought that if you're successful, you get to take funding away from a state agency for their failure to implement a policy correctly could certainly have some detrimental impacts in terms of their ability to improve their enforcement down the road. So I wonder if you could speak to the pros and cons of that approach as a strategy.
So the sort of Damocles sword hanging over an agency's head is the removal of federal funds or not granting the money in the first place. But in fact, once an agency has done that once or twice, the recipients of federal funds take them more seriously. And that's indeed what's happened in the Education Department and Health and Human Services Department. So in my pretend call from the Department of Education to whoever it was, Burlington or wherever, Montpelier, chances are money was never taken away from that school district. What happens is the agency has developed a sense of respect. They've developed policy guidance so that the recipients have a better sense of what's expected of them, and they run their office in a professional way. And then recipients will say, okay, you have found a racially disproportionate impact. Let's talk about what I should do. And the far and away, I mean, they can withhold federal funds, they can make a referral to the Department of Justice. There are a lot of tools at the disposal of the agency, but even the statute says that before you withhold federal funds, you have to make that call. You have to give an opportunity for voluntary compliance. And so what usually happens is the agency makes the call and they come up with an approach to voluntary compliance. Sometimes the community isn't happy with the sufficiency of that remedy, but it moves the ball down the court. So a lot of civil rights compliance under Title VI in the agency context is not withholding federal funds, but once the possibility of withholding federal funds is out there, there's the possibility of using that leverage to make meaningful change. And that's how it works.
Folks, if you have questions, you can line up.
Hi, thank you for your vivid stories. How has
I
Title...
think that was a referral to the dead bodies there. Yeah.
Everything. How has Title VI or other legal measures been used to address the problem of unequal enforcement, be it lower detection rates or lower penalties given to environmental violations in low-income communities and communities of color?
Yeah. So there are two types of cases that could be brought to address unequal enforcement. One is to say if there are similarly situated communities and a recipient of federal funds or a government agency is treating them differently, that you can bring an intentional discrimination case under what's called the McDonnell-Douglas construct of proving intentional discrimination by inference. So we've actually looked at a state where we believe that that occurs, that people call in from communities of color and they say there's an environmental problem and the agency says, another complainer. We've actually seen emails that say that. And then we've looked at the complaints that are filed by people in white communities around facilities, and they say, send an inspector out there. Now, obviously, it's not quite that simple usually, but that's what we found. And so we've started to say, okay, well, could we develop a case of intentional discrimination to challenge that disparate treatment between the communities? So that's a real possibility. Hasn't been done all that much. There are a couple of intentional discrimination cases, not so much for the enforcement side, but that under Title VI that have, and under the Equal Protection Clause that have gone through the courts, that have survived motions to dismiss, and it's something we're looking seriously at. There's also the possibility of a disparate impact case. So if you have a mechanism that's the way in which they do the enforcement, maybe it's a rating system, maybe it's some other facially neutral approach that when it's used, it has a racially disproportionate impact, and you could do it a different way. There is a less discriminatory alternative, so you could rebut that justification, this is the way we do it, it's facially neutral. Then you could file a complaint with the agency that gives federal funds and challenge it under Title VI. Again, in this administration, you'd have to build your record and advocate strongly, and there might be ways to engage in some kind of negotiation. I will say also, in some states, you can use state civil rights laws like California that also have a disparate impact standard.
Thank you.
What's new?
I haven't seen this yet, so please.
So is Kyron here? Not here this evening. Everything I know about environmental justice, I learned from Kyron. So I understand there are all these failures of process and procedure and putting the cops on at the door if the hearing is held in the community, but not if it's held in Lansing, and disparate responses to complaints, and nobody can defend that, and it's easy enough to see what the remedy ought to be in a reasonably perfect world. But what I'm interested in is sort of the fundamental problem of what to do about disparate pollution. So in North Carolina, there are all these plants, pig operations that are concentrated in a particular area, and not coincidentally, that is an area of high concentration of African Americans, and it doesn't take a PhD degree to figure out what the causal connection there is. And so I understand you could, under Title VI, you can go and say that's terrible and you ought to take money away and so on, but what I'm interested in is what is the ultimate remedy that EJ advocates want. So you say, well, the problem here is that presumably all these facilities are lawful, right? They wouldn't be permitted otherwise. I mean, some of them are actually unlawful, but most of them are lawful because we license people to pollute in this country, right? And one of the big problems with environmental justice is not that there are a whole lot of illegal operations, but there are a whole lot of legal operations concentrated in one place, creating a large concentration of impacts on a particular community. So what's the solution? And I guess it seems to me there's sort of one of two things. You say the state of North Carolina should say no more pig operations in this area. We're going to redline this area. This is a no-go zone for anybody who has an idea of starting a pig operation, and they got to go elsewhere in North. If they're going to be in North Carolina, they got to go elsewhere. In other words, this is what Kyron taught me, is that one of the implicit objectives of environmental justice is this stuff is awful, it's a pain in the neck, it's smelly, and everybody has to share in the pain. And that in Grosse Pointe in Michigan, they get to have some. It's not just in Flint. It's in every community in Michigan gets to have some offensive use. And then if we apply it broadly, then there is no disparate impact. I mean, I guess the observation about that, and that achieves justice. It strikes me as, if you frame it that way, and maybe I've framed it in too inflammatory a way, it seems really likely to generate incredible political opposition. But that seems to be the implication. The other alternative...
Maybe you should stop, and I'll try to answer that, and then ask your second question.
No, but the second question is just the other shoe
I'm losing track.
The other shoe dropping. So the other alternative is to say...
If you think you can manage him...
The other thing is say, no, we're not going to spread it around. We're not going to annoy all those people in Asheville and get them all worked up, right? We're going to live with the fact that there's some concentration, but justice must be achieved, and so therefore the appropriate remedy is to pay the people with money financed by the taxpayers of North Carolina to the victims of all this concentrated environmental harm. And so it seems to me it's sort of the end of the day when you get through all the process and you're dealing with the current existence or future prospect of concentrated environmental harms. Either you pay people off or you, as I say, redline the offended areas and start spreading the stuff all around.
Okay, so I have so much to say, and that was obviously not embarrassing yourself. That was a lot of many, many good questions. So let me see if I can unpack some of it. I'm not really going to go in the direction of paying. There are tort cases. In fact, a law firm of Wallace and Graham has brought a series of tort cases in North Carolina on behalf of hundreds, if not thousands, of community members. They've been wildly successful. There are damages caps in North Carolina, but they've gotten hundreds of millions of dollars. We actually filed an amicus brief in an appeal by the industry to the Fourth Circuit to challenge the first verdict under right to farm ideas. So that all is happening. But the communities, it's funny, we have a case in Uniontown, Alabama, and Jameson is over there, he's working on the Uniontown case. And we filed there are 2 complaints, one for intimidation and one for discrimination with EPA in this case. Uniontown is a very low-income community. It is 90% African American. It's enormous, the largest landfill in the state of Alabama, and it took 4 million tons of coal ash, which were sent from Kingston, Tennessee, across state lines to sit across the street from this the residence in 2,000-person Uniontown, Alabama. And they filed a civil rights complaint, went to EPA, and when I first started meeting with EPA, they said, what do they want? Do they want to be bought out? And honestly, the community had never talked to me about being bought out. Their loved ones are buried in this community. They have community in this community. They have churches in this community. They want that landfill closed. Or if it's not closed, they want it to take no more coal ash. Or, I don't have to go or, because they don't want any more coal ash in their community. They want protections. When I first got there wasn't even a fence around this facility. So animals come in and out. They want equal protection. It's not a question of putting a special condition in an African American community or a Latinx community. They're being dumped on, and they want the dumping to stop. So it's sort of that simple, and that's basic fairness. And I think we can all agree that we need basic fairness. But the other thing is, if we had basic fairness, we'd all be in the same boat. The reason it's a problem that coal ash went to Uniontown, that it has the largest landfill that can take waste from 33 states, the entire eastern seaboard, and dump it all in this low-income community of color, is not just because that's wrong or unfair or people believe that it's killing them. That's all really horrific. But it also puts that waste out of sight, out of mind for the rest of us. And until we all have an equal stake in how we handle waste, how we handle pork production, we're not going to make the changes. We're not going to make the changes in the permit. We're not going to make the changes in RCRA that governs municipal solid waste facilities. They'll continue to take coal ash. We don't have a stake in it. People tell the story, I'm on the board of We Act for Environmental Justice, and they fought for years about the sewage treatment plant between 138th Street and 148th Street in Manhattan. And by God, there needed to be a sewage treatment plant to stop the dumping of waste in the Hudson. But when it was put there and the smell from those stacks went over to West Harlem, where the asthma rate was already out of control, and people complained and complained and nobody listened to them. It wasn't until people started driving down the West Side Highway and said, what's that smell? And there were people from the New York Times, as I understand it, who drove down the West Side Highway and said, that can't be right. That's when they got attention. You put something in the place where the people with the least power in society, they may be asking for power. It's not out of ignorance. They're asking, they're bringing, like in Flint, they're bringing those water containers with all of the dirt, all of the lead in the water container. They're saying, listen to me. And what happens? They're being dismissed with callous disregard. So until we have fairness and the equitable distribution of health hazards, we're not going to have systemic reform. And that's why we have to do it. Before Jameson, I want to answer or try to respond to what I think is the toughest question you asked, and it really is a tough question, which is, what's the remedy? How much is enough? And I think we struggle with it. I don't struggle with what does the community want. I struggle, though, with, okay, we can show impact, we can show it's disproportionate, we can show that there's a rebuttal to the substantial legitimate justification. My goodness, we're not anywhere near your question in North Carolina. There's so many things DEQ could do that would be relatively simple, not politically simple, but to protect people more. There's so many things Alabama Department of Environmental Management could do to simply protect people in Uniontown at the same level that they protect other people. So we're nowhere near. But if EPA started to enforce the law, and if they started to say there needed to be a remedy, how much would be enough? I think that's a really challenging question. We're not there yet, though. Jameson.
Thank you for an awesome lecture. You were very open about the EPA, obviously, so I actually kind of want to ask you a question about NEPA. Obviously, NEPA requires agencies to assess impact, either find a FONSI or go to the next step of EIS. And then NEPA also, obviously, Section 2 brought forth the CEQ. And I was just kind of wondering how you felt about that process and how you felt about the job that the CEQ is doing, because it's their job to implement and make sure the implementation of NEPA is happening correctly. In my time in the clinic, I've been exposed to that process a lot more, and seeing that process has quite a few cracks in it in terms of holding people accountable, engineers that are doing these studies, environmental engineers who are doing the EAs and things of that nature. Just kind of see what your thought process is and what your mindset is in terms of how NEPA and the CEQ are doing in their job of making sure that they're holding people accountable for those instances.
Thank you for the question, Jameson. There's so much to say about NEPA, and you have experts in the room, so I'm not going to tread too far in that direction, but I think it's a great question. Let me say a few things, though. One, NEPA is extraordinarily important to our work and to the communities we represent. It provides the opportunity to weigh in. And if I think about what are the cornerstones of environmental justice, it's one, distributive justice, and we've been talking a lot about that. The unequal distribution of environmental benefits and burdens. Second, sort of substantive justice, whether you have access to clean air, clean water. And third, procedural justice, whether there is the right to have a say in your own future, in the future of the health and welfare of the community. And NEPA is a really important legal vehicle for saying, okay, if something major is happening, if there's a major federal action or the little NEPAs in 20 plus states, if there's a major action that meets the standards for one of the little NEPAs at the state level, that there is this process for assessing whether there are significant impacts. And in many cases, the community does have the opportunity to weigh in through the notice and comment period, through a hearing. And those processes have been very important to communities and very important to improving projects. Quite often communities weigh in and there are changes to the project, and sometimes it can be very frustrating, but they've been cornerstone. NEPA and Title VI are also the foundation for the Executive Order, Executive Order 12898, the Environmental Justice Executive Order. It was on the basis of the power of the executive under NEPA and Title VI that President Clinton signed the Executive Order. So it has this both historic and practical foundation and a starting point for the procedural justice sought by the environmental justice community. Now, having said that, that potential is not always met, right? And one of the things that we're looking at in the clinic is the advance notice of proposed rulemaking that went out a while ago at CEQ, saying that the administration may rethink some of the basic standards that CEQ has put out for agencies to follow, whether it's in public participation or the way we look at cumulative impact. And the clinic is working with EJ groups to figure out how we get a jump on comments to make sure that we can support the strength of NEPA as it's used by EJ communities.
Thank you.
Thanks, James.
You mentioned tonight the issue of pollution levels below regulatory thresholds being ignored. And we've talked about it in the clinic too, but in your opinion, what's the best way to attack this issue?
Great question. So the question comes out of the concern that EJ communities have voiced since Select Steel in 1998, that EPA has conflated regulatory standards that come out of a regulatory process under the Clean Air Act or under FIFRA for pesticides with a finding of whether there's an impact under the civil rights law. And there's a long history of the civil rights law being litigated before 2001. We have a sense of what an impact means. And even more recently by administrative agencies. In the clinic, we read a case called Beaver Creek. Beaver Creek comes out of Correct me, am I Dayton or Akron? Akron, thank you. Akron, Ohio, where the Regional Bus Authority wanted to place 2 new bus stations across from a mall in Beaver Creek, which is a predominantly white suburb of Akron. I keep forgetting which it is. And what happened was, within about 18 months, the Department of Transportation had received the complaint, decided it would take the complaint, and ruled on the complaint, finding that there was unjustified disproportionate impact. What had happened was the community said, you can't put these 2 bus stops outside the mall in our suburb. If you put the bus stops outside the mall in our suburb, you have to do more than 10 things that you don't normally do when you site a bus stop. You have to have a thicker pad underneath where the buses stop so the street isn't torn up. You have to have a video camera so we don't have any crime at the bus stop. You have to put a bond because we're worried that the bus stop will be destroyed. There are all these additional requirements that didn't apply anywhere else in the bus system. And the argument was this had a disproportionate impact on the basis of race, disproportionately people coming from the city to get a job or to shop at the mall would be people of color, and this was a suburb that was predominantly white. The Department of Transportation, when it did its investigation, found that the Regional Transit Authority never had these kinds of requirements in their other bus stops. They just weren't required, and that there would be a disproportionate impact. And the line about the impact is about 1 sentence long. It says there's a disproportionate impact. They didn't do a study to see how many people were killed as you walked from the other bus stop a mile away down the highway to this mall. They didn't do a study of how many people would lose their jobs. They didn't do any study. If you don't get something that's good, that's a harm. If you get too much of something that's bad, that's a harm. You don't have to find there's a significant impact. You have to find that there's an adverse impact and that it's disproportionately, significantly, to a significant statistical level, disproportionately affecting people of one race versus another. That is just a good example that we don't need to find significant harm. We don't need to turn ourselves into a pretzel to say we're missing, we're exceeding some threshold. If you have more lead in the air, that's a harm. People will be exposed to more lead. No, there is no safe level of lead. That's relatively simple. So how do we deal with it? We have to keep advocating with EPA. I will say during the Obama administration, this was called, by the way, the rebuttable presumption. Select Steel found that if you're complying with environmental thresholds, that's a defense to a disparate impact case. Of course, that will defeat any disparate impact case by and large. If you have a new permit, of course the new permit is going to say we're going to comply with environmental thresholds. And if you have an old permit and they're exceeding environmental thresholds, if you find they're exceeding an environmental threshold, the facility will say, oh my goodness, I'm so sorry, I'm going to fix the problem. And you'll never have impact. So it absolutely was the exception that undermines the rule. And so during the Obama administration, this was the #1 issue that communities talked about. Get rid of the rebuttable presumption that compliance with an environmental law is a defense to a disparate impact claim. In theory, EPA did that. They put forward this thing called a toolkit or a chapter in a toolkit. In the FAQs, the frequently asked questions, and the transmittal letter to the toolkit, it says there's no rebuttable presumption. But lo and behold, as soon as they got that out the door, in some of our cases, they used a rebuttable presumption. So we have a lot of work still to be done.
How about a thought exercise?
Okay.
February 2021, President Harris issues a directive to EPA Administrator Cortez. Says, I want an investigation of the state of North Carolina's compliance with Title VI. Cortez does. Produces a finding, rampant, disproportionate impacts, callous disregard, intentional discrimination based on race. 2 questions. what does Cortez put in the corrective act? And Cortez says to North Carolina, in light of my finding, I'm inclined to withhold all financial assistance, federal assistance, under all relevant statutes. Clean air, clean water, RCRA, CERCLA, all the acronyms I can think of, okay? All the money cut off, unless you do the following. What's the following?
Okay, I thought you had two questions.
The next question will be, what happens then?
Okay. So let me take what happens then first, although it depends on the answer to the first question. There are many possible answers of what happens then, and I'll use the old "it depends," but two of the things that could happen is there could be a revolution, right? You know, you could have like the Department of Education applying Title IX to bathrooms or something, and in North Carolina as well, and then people say, we're not going to comply, and then you have court cases, and that's probably, and I should say that if an agency threatens to withdraw federal funds, the recipient of federal funds has due process rights, and so they can challenge that withdrawal of federal funds through an administrative process, and if they lose in the administrative process, they can go to court. So that revolution I'm talking about really would take place in court if they were grossly unhappy. I will say on the positive end, even if it were like extreme, major change of the kind communities might want, people would take EPA seriously for once. I mean, right now we have rampant noncompliance, and nobody even stops and thinks, we have to figure out whether or not this action we're taking complies with Title VI. And we have to go through the thought process of saying, will this general permit for 2,000 facilities comply with Title VI? And if not, what do we need to do, right? They don't even go through that process. And so if, like in the area of education, like in the area of healthcare, if recipients of federal funds finally were held accountable, the hope is, like in those other areas, it would start to inculcate a different way of thinking about whether or not you're complying with Title VI. So that's what would happen then. Going back to your first question about what's the kind of corrective action. So in the Michigan case, it's sort of a funny story. So the Obama administration's leaving office, and they send Father Phil Schmitter and us as counsel and MDEQ a letter saying we're finding you to be in violation of Title VI for intentional discrimination. And they send a list of corrective actions. And the corrective actions include, you got to have a Title VI program. You got to have a coordinator of civil rights. You have to have a complaint program. You have to have language access policies, public participation policies. You have to have a robust program. Let's start there. Michigan says, wait a second, where do I see that in your regulations? Where do I see that in your guidance documents? And you know, in part, they weren't entirely right. EPA does have a guidance document about language assistance, and they do have a guidance document about public participation, but they don't have a final guidance document about the programmatic requirements of Title VI. If you compare that with the Department of Transportation, for example, the Department of Transportation has a really well-developed circular that says if you're, say, a transit agency over a certain $1 million and you're changing your service, you have to do an equity analysis, and you have to send it to us. If you're applying for funds, here are the things you need to do, and you have to send them to us, and we have to post it on our website. So there are clear requirements. So the predecessor to Cortez's letter should be having a guidance document that says, here's what you need to do. Doesn't cover all circumstances, but here's what you need to do. Here are the different contexts in which you need to do it, and then we're going to hold you accountable for that. Okay, last question.
Okay. Can you talk about the challenges of proving intentional discrimination?
The challenges of proving intentional discrimination? Okay. So When I was learning to practice civil rights law at the NAACP Legal Defense Fund in the late 80s and 1990s, it was sort of understood that it was more difficult to show intentional discrimination. Polite society did not say things overtly that were discriminatory, and we all tried to work with each other in a way that was reflective that we had gone through the civil rights movement and we should be treating each other with respect. Some of that level of decorum has disappeared. Just want to put it out there. And so we're starting to see intentional discrimination cases. The policy may still be facially neutral in the voting rights area, for example, but the underlying information around that, the context has changed dramatically. And so I would say that we're rethinking what we had thought was the norm, that it is more difficult to show an intentional discrimination case. There are essentially 3 ways of proving intent, right? You have direct evidence of, well, 4. You have something that is facially, uses race in an explicit way. Secondly, you have a facially neutral policy, practice, or program, or event, or something. But you can show that though it was facially neutral, there was something explicitly about race that underlies it. Or if it's facially neutral and you don't have that kind of evidence, you can infer intent either under the McDonnell-Douglas test that we talked about before, where there are 2 people or communities that are essentially similarly situated, but for race, but they're being treated differently. And then you have to go through the whole analysis of whether there's a reason, a business necessity reason, whether there's or a bona fide qualification, and whether or not that's pretextual or can be rebutted. On the other hand, there's the Arlington Heights test, right? That says, okay, you have a facially neutral policy, practice, or whatever, and we can accumulate lots of evidence that shows that really what's going on is intentional discrimination. And in the environmental context, outside of the answer to the question about enforcement that I gave before, where we might use the McDonnell-Douglas test, people usually think that you use the Arlington Heights test. This is from a case called Arlington Heights and an opinion by Justice Marshall. And what he said was, I'm going to give you a non-exclusive list of factors that could amount to a showing or an inference of intentional discrimination, a tie to intentional discrimination from the past, irregular procedures like I talked about in the MDEQ case, the historical context, egregious disparate impact. All of that says that this was foreseeable and intent can be inferred. So what's required depends on the circumstances and how difficult it is to dig into those facts. And I think some of the barriers are just having the resources and the time to dig into the facts sufficiently to get into court, to get the discovery, and to do that work. Is it impossible? No. And are communities thinking about it in all kinds of contexts? Yes. Thanks for the question.
Okay, thank you so much, Professor. I'd like to invite everyone to join us for a reception, and hopefully we'll have time for more discussion if you didn't get to answer or ask your question up until now. Thanks so much.